Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Law of Torts, we were discussing from last two class as to whether it is Law of Tort or Law of Torts. And in that series, this is my third video where we are going to discuss the pigeonhole theory or the narrower theory, which is contributed by Sir Jon Salmond. Now let us try understand what does Sir Jon Salmond has to say and who supported him, who stood against him, all of that with the help of case laws. Not taking much of your time, let's get into the first slide. So what have we understood in my last class or while discussing wider theory? We have understood there that if there was a civil wrong committed against a plaintiff by the defendant, and if the defendant has no legal justification, in that case that civil wrong will be considered as tort whether it has a name or not. Whereas Sir Jon Salmond has to say that there are already predefined torts like negligence, assault or battery, slander or defamation, or few other decided cases are there, or the decided torts are already there. Now if any civil wrong has been committed by a person and if that case is coming to the court, in that case plaintiff has to convince the court that it is falling under any one of the already defined tort. Only in that case there will be some compensation given to the plaintiff, which is what the narrower theory is all about, or this theory is famously known as pigeonhole theory. Let us try understand the pigeonhole theory in detail in my next slide. Let's try understand the pigeonhole theory with the example of the pigeonhole itself. Now if you see the image, there are pigeonholes and in every pigeonhole there is a pigeon. Likewise, Sir Jon Salmond says that there are torts which are already defined. Just like in every pigeonhole there is a pigeon, there are torts which are already been defined, just like negligence, assault, defamation, nuisance, malicious prosecution, etc. They are already been defined by the courts or the pre-decided cases. Now they have a name, and if there are any cases coming into the court hall, the plaintiff has to prove that the case will fall under one of these names. These names which I have mentioned here are not limited. There are many more which are already been decided. Now if the case is falling under any of these pre-decided names of tort, only then the court will consider the case. So it is not just about the civil wrongs, it is about justifying that such civil wrong is falling under the name of one of the predefined tort. That is what Sir Jon Salmond has to say. Or undefined offences and wrongful conduct would not come under the purview of the liability in tort of law, which is what this theory believes in. Unlike the wider theory where every civil wrong which has any justification by the law, which doesn't have any justification by law, will be considered as tort, whereas here that is not the case. Here if you are bringing a case, you have to prove that it is falling under one of the predefined tort itself. Only then it will be considered. So that is the main thing that we need to understand from the pigeonhole theory. Now let's hear from the man himself what Sir Jon Salmond has to say in my next slide. Sir Jon Salmond says, and I quote, "Just as criminal law consists of a body of rules establishing specific offences, so the law of torts consists of a body of rules establishing specific injuries." What does he mean to say there? He says in criminal law we have defined offences available, and just like that in law of torts we have defined injuries available, which is what he means to say in the first line. Moving further, he says, "Neither in the one case nor in the other is there any general principle of liability. Whether I am prosecuted for an alleged offence or sued for an alleged tort, it is for my adversary to prove that the case falls within some specific and established rule of liability, and not for me to defend myself by proving that it is within some specific and established rule of justification or excuse. He says it is the liability of the plaintiff to prove that such civil wrong which is happened against him is falling under one of the predefined torts, and it is not the responsibility of the defendant to prove that it is not falling under one of the predefined torts. So the plaintiff has the liability to prove that such civil wrong which has happened against him is falling under one of the predefined tort, which is what Sir Jon Salmond has to say. Now, when you start writing about Sir Jon Salmond, also mention that he is the author of the book The Law of Torts. So his definition is quite lengthy and lot of English there. If you ask me to define it very simply, I have given one single line there. No injury is a tort unless it falls within the specified category of any accepted tort or predefined tort, and who has the liability to prove so? The plaintiff who is bringing the case inside the court hall has the liability to prove that the civil wrong which has happened against him is falling under one of the predefined tort, which is what you need to remember. And if you are looking for a case law for supporting the narrower theory, please refer the case law Bollinger versus Costa Brava Wine Company Limited, where in this case it was opinioned by the justice that before a person makes a claim for damages in law of tort, he or she must prove that the case is well within the sections or the pigeonhole of actionable wrongs. That very clearly supports the theory of pigeonhole theory. I hope that gives sufficient notes as far as the basics are required. Let's get into the last slide where we'll understand the criticisms and support for the pigeonhole theory. Let us start the discussion with the criticisms against pigeonhole theory. Now, what happens in wider theory? If there is a civil wrong, such civil wrong is brought inside the court hall and there is no need for the plaintiff to prove that it is falling under any of the predefined torts. He has to only prove that there was a civil wrong and it has caused legal injury, and the defendant doesn't have any legal justification. If he is able to do so much, he will get compensation. Whereas here in this case, what happens? In pigeonhole theory, if a civil wrong was brought inside the court hall, the plaintiff has to prove that such civil wrong is falling under one of the predefined tort. Now that is the additional responsibility. So there comes the first criticism, which says this doesn't give space for new torts which are not in any way similar to those which are already existing. Now that is the first criticism, and then comes the second criticism, which says this is also limiting the scope of law of tort. Now the subject will not become more and more elaborate because we'll keep discussing only about the predefined torts, so that limits the scope of law of tort, which is the second criticism. The third one is very important. Modern era has modern wrong, and if we are limiting it to law of torts, then there is no space for the new torts, which is what the third criticism. The fourth one, there are no opportunity for the courts to apply their mind in law of torts because it always makes the discussion to go round and round in proving whether such civil wrong which has come inside the court hall is falling under the predefined torts or not, and if it is not falling, the case will just go off. So that way there is not giving any opportunity to the court to apply its mind. And then came series of cases which gave lot of new torts. So that way criticizers said that these are the new theories which are in front of you, which are civil wrongs which are causing injury to the legal rights of the plaintiff, and there is no justification by the defendant on these legal injuries which is caused by them. So that way they are taught and they need to be considered. I have given the series of case laws. We have discussed what was the contribution of those case laws in my previous video. You can go for reference. Now these are all the major criticisms against the pigeonhole theory. The last part, supporters of pigeonhole theory. I have three very important thoughts by Dr. Jung, Hewson and Dr. Williams. What are their thoughts? They say Sir Jon Salmond's pigeonhole theory is misunderstood or misinterpreted. Now they say all that Sir Jon Salmond has to say is there needs to be similarity between the torts which are coming new inside the court and which are already decided, or there is always a scope for adding new pigeonhole, or the existing pigeonholes can be expandable. All of these statements are given by the supporters of Sir Jon Salmond. Now you can quickly read through the thoughts of Dr. Jung, Hewson and Dr. Williams. That also brings the end to our third discussion, and in my last discussion, that is in video 4, we are understanding the Indian scenario, and with that I am handing over this presentation to Nishan.
When Papa says tort, lot of tortoise come into my mind. Look at them. With that I am concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye bye.